Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 and the K-3 visa. These are both K categorization visas. They are for the spouse or the fiance of a United States citizen. Let me be clear on that. The K categories only pertain to the fiance or spouse of a United States citizen. A K-1 visa is designed for the fiance of an American citizen. The K-3 visa is designed for the spouse of an American citizen. What are the differences between these two visas? Well, as the title suggests, the K-1 is used to bring a fiance into the United States, someone with whom one has not engaged in a legal marriage yet, but plans to in the United States within 90 days of arrival in lawful status. And the K-3 visa is designed for the spouse of an American citizen. So this is an individual that's already engaged in a legal marriage, either abroad or in the United States, prior to coming into the U.S. A couple of things to note: both of these visas are non-immigrant. Even the K-3 for his spouse is not an immigrant visa. I've gone into this pretty well at length in other videos on this channel, but the K-3, although a non-immigrant visa, allows for adjustment of status in the United States or for one to go ahead and process their immigrant visa at a U.S. embassy or consulate abroad. The K-1 is much more constricted in its approach. Basically, it provides only 90 days of lawful status for the fiancé of an American citizen. Within that 90 days, the couple needs to go ahead and get married and file for adjustment of status. K-3 visas generally, I believe at the time of this filming, are issued in 2-year increments, whereas K-1's, again, 90-day status. Now, comparison and contrast. Well, first of all, let me be clear. The K-3 visa is not an overly optimal visa as of the time of this filming. One reason for this is so-called administrative closure. We've done videos on this channel regarding administrative closings of K-3 visas. To summarize very quickly, basically, if the immigrant visa case underlying the K-3 visa supplemental petition reaches the National Visa Center prior to the K-3 reaching the National Visa Center, the K-3 will simply be closed. As of the time of this video, many of the K-3s are being closed because they are the underlying immigrant case is moving faster. This is due to the fact that the K-3 was actually invented as sort of a time-saving or fast-tracking type of visa. It was basically invented under the provisions of the Life Act under President Bill Clinton. And basically, they were invented at a time when an immigrant spousal visa could take 4 to 6 years in some cases for the spouse of an American citizen, while it was 4 to 6 months for the petition to be processed on a fiance visa. So Congress basically said that issue needed to be rectified. They created this K-3 category, which essentially gets to use the K-1 processing line, and they sort of fix the issue. But that being said, since that time, USCIS has massively streamlined the processing of immigrant cases, immigrant petitions, and it's effectively phased out the K-3. The thing when looking at these, though, at the end of the day, is a K-1 really is for a fiance. So if if the situation isn't quite right to go ahead and get married, maybe a K-1 fiance is the better way. Fiance visa is the better way to go. Contrast that with a couple may already be married and they simply may want to try to get to the United States faster than with an immigrant visa, and under those circumstances, a K-3 may be the way to go. That being said, they are substantially different types of travel document, and notwithstanding the differences in sort of the inherent differences there, adjustment of status is still required once physically present in the United States.